Who can be evicted in California? It has been a week and a half since AB 3088 was passed. We're here to answer your questions and give you some more updates. Hey there, Christian Walsh, Coldwell Banker Weyer Associates. We are real estate brokers who specialize in helping tenants and landlords, buyers and sellers in lovely California, and we are here to answer your burning questions about the COVID-19 Tenant Relief Act of 2020. Since we posted our last video, we've had a lot of questions come in, so we want to give you the updates. We want to give you those answers. So we have a lot of ground to cover. We're going to talk about who can be evicted. We're going to talk about when landlords can start evictions. We're going to talk about at-fault just cause versus no-fault just cause. We're going to talk about non-payment of rent due to COVID-19 and evictions. We're going to talk about AB 1482 and AB 3088 and how those come together. We're going to talk about the CDC eviction moratorium and AB 3088. And then we got some frequently asked questions in this past week and a half, the questions you've been asking. So we have a lot of ground to cover. I'm going to use the YouTube chapter section so you can listen to any of them that you need to hear again. And if you are ready to dive in, I need you to hit that like button before we go. So very important advice. Like I say all the time, I can't give tax or legal advice. And this bill, AB 3088, has a lot of nuances, has a lot of idiosyncrasies. So it is absolutely necessary before you move forward with notices or evictions that you make sure you talk to the appropriate professional, an attorney who understands AB 3088. I was just talking to one of my YouTube viewers, and she mentioned that she was calling an attorney for help. She asked him, hey, have you heard of AB 3088? And unfortunately, the attorney said no. So that's goodbye. You need somebody who knows what they're doing, who understands AB 3088 and has heard of it. So my YouTube viewers know I really like whiteboards, so it's time to do another whiteboard demonstration. And what we're talking about is at-fault versus no-fault evictions. And this is where AB 3088 really changed things, and it works in conjunction with AB 1482, which we'll talk about in a little bit. But what we're going to discuss are exactly when a landlord can evict and move things into the eviction process. So at fault versus no fault. What do we mean by fault? It's basically the tenant. Is it the tenant's fault for doing something, or is it not the tenant's fault? And you'll see the tenant's fault, it's a much longer list. If it's not their fault, it's a very short list. So we're going to run through a few things. So for at fault, the biggest one is actually non-payment of rent. And what's surprising there is that you may say, well, AB 3088 is basically letting tenants stay there without paying their rent due to COVID-19. So that is important. That's one of the things, the biggest reason that tenants default. So another one would be the breach of the lease. So if the lease says no smoking and they're in there smoking, then they're out. Another one is nuisance. And nuisance has a legal definition. We actually included a link below so you can figure out what that means. Next one is criminal activity. So criminal would be if they've committed a crime on the site or if an unlawful act is going on in the unit. So that would be criminal. Another big one, and this is one we see often, is subleasing without approval in the lease. So you can't be bringing in roommates if you're a tenant unless you have approval on the lease. A good solid lease is going to stipulate that you can't do it without landlord approval because the landlord doesn't want to get stuck. Then a big one would be if you don't move out after you're given a correct, proper legal notice to terminate your tenancy, you can be evicted. Unlawful detainer can start if you don't move out. So now let's go through no fault. So AB 3088 really tightened that list up. So it's just a few different things. One is if the property is being sold and the buyer is moving in, then the tenant can be given a 30 or 60-day notice. The next big one would be a court order to make it vacant, to tear it down, or to fix it up. So this is a big change that the bill made, and we'll discuss a little more in a bit to AB 1482. Before, you could give a 30 or 60-day notice and have a tenant move out. If you're going to do a substantial upgrade, that's gone. It has to be a court-mandated substantial upgrade. And then the last one would be if a lease is coming to an end or a tenant is month to month, and then a 30 or 60-day notice can be given if a family member is going to move in. So if the owner wants to move in, and this has been one of our biggest questions. So it could be the owner, it could be a child, a grandchild, it could be a parent, a grandparent, a spouse, or domestic partner. That's it. So a brother technically couldn't move in. So again, the reason we're going through these is this is the list. So when somebody asks, when can I evict? When can a landlord evict? It's for these things. And that's about it. That's all that's on the list. So it's very much tightened up. And then we're going to dive in and explain too, non-payment of rent, how that works now with COVID-19. So now we'll talk about where AB 1482 and AB 3088 overlap. I've done a bunch of content on AB 1482. It is a statewide California law that went into effect on January 1st, 2020, and it put two things into place. One is a rent cap. It prevents rents from being increased more than 5% plus the consumer price index. The second thing is just cause eviction requirements, and that's where we get the overlap with AB 3088. So what AB 3088 said is that some of the exemptions that we had with AB 1482 are gone. In other words, AB 1482 said that single-family homes, condos, townhouses, and any properties newer than 15 years old are exempt from the just cause requirements. But thanks to AB 3088, those properties lost their exemption. They now fall within the just cause requirements. They also, in this bill, in AB 3088, tightened up what just cause means. Now, I ran through at fault versus no fault just cause, and really what it did is it shrank down. The bill shrank down the no fault side of things. And like I said, you could have given a notice to terminate tenancy if you wanted to do an extensive remodel. Now you need a court order to do that extensive remodel. This bill is also apparently preventing you from giving a notice to non-renew. So you basically are stuck with your tenants unless you fall within the no fault, the tight no fault just cause requirements of you are a very close relative moving in, a court order to tear it down, make it vacant, or fix it up, or if you're selling it and the buyer is going to move in. So that's how the bills overlap. Basically, what it did is it took AB 1482 and ratcheted it down, made it even tighter. So that's what we have to deal with thanks to AB 3088. We're back at our whiteboard for one more, and we're going to talk about the biggest reason people are evicted, which is non-payment of rent. That is the biggest at-fault reason for eviction, but things have changed because of AB 3088. Now, we ran through this in our other video, but we're going to tell you a little bit more, dive in a little bit deeper. So first things first, if a tenant did not pay rent before March 1st, the bill says that an eviction can move forward starting 10/5/20. So that is when landlords can move forward for any rent that was before March 1st that was owed, and there are folks who didn't pay back then. So here's where the distinction is, and we've got a line right down the middle. The bill was passed 8/31, and it had different ways of handling the different time periods. There's two time periods: before the bill was passed, after the bill's effective. So for this time period, in the past, the landlord has to do certain things, the tenant has to do certain things. So the landlord is going to deliver a proper notice, and the landlord is going to deliver a blank declaration, which we have a copy below. The tenant has 15 days to return this declaration, and those 15 days don't include weekends or judicial holidays. So it's quite a bit of extra time. So the tenant turns back in a signed declaration under penalty of perjury that states they can't pay their rent due to COVID-19. If they're a high income tenant, which we're going to talk about that in our frequently asked questions later, we'll discuss what that means, but they have to, if they're high income, they must return their proof. So that is what needs to happen for any rent before that a tenant missed. So when can a landlord move forward with an eviction in this case? If the tenant does not return the declaration and or the proof, if they need to, the landlord can start moving forward on an eviction on October 5th, 2020. Now the tenant can go ahead and perfect it, meaning they can, if they get in front of a judge, they can explain that they weren't able to turn in the declaration, and then they can turn it in then. So this is not a perfect system, so a tenant still can perfect and turn the declaration in. All right, so going forward, so for September through January, it's a slightly different process. Still the same thing, the landlord will deliver the notice and the blank declaration, and those will go to the tenant each month they miss rent. So if they miss it each of those months, September, October, November, December, January, that has to go out each month. The tenant does the same thing. They have 15 days to return the declaration and the proof, plus 25% minimum of their rent must be returned, okay? Now, the law says that it doesn't have to be turned in until January 31st, 2021. So the tenant technically could pay nothing up until the very end and then make sure that they have 25% of each month. So it'd be 125% of 1 month if they miss 5 months, because it's 5 times 25%. So when can the landlord evict in this case, or start the eviction process? If the tenant doesn't return the declaration, then they can go ahead and start the eviction process. But like we said, the tenant can get in front of the judge and still deliver it. If the high income tenant does not deliver proof, again, you can move forward. If the tenant doesn't turn in the 25% minimum of rent, so if they wait the 5 months and they don't turn it in by January 31st at 125% of 1 month, or 25% of each month, that's what it adds up to. If they don't turn that in, then the landlord can start the eviction process on 2/1/21 for non-payment of rent. Another important distinction, if the tenant does everything right, they turn in all the declarations and proof if necessary, and they pay the 25% each month minimum, they can't be evicted for the other 75%. And I've seen some other folks out there giving incorrect advice, but you cannot evict. If the tenants follow through and do everything they're supposed to, per the law, that 75% they owe, they can't be evicted for not paying it. Now what it'll do is the landlord will go to small claims court to recover that debt, and that would be the 75% for here and anything that wasn't paid here. But no eviction can move forward for not having paid that. We promised to mention the CDC eviction moratorium versus AB 3088. This has been a big question for a lot of folks. Which one do we use in California? Well, the CDC eviction moratorium, which came out a few days after, has specific language that says that if states or local jurisdictions have protections that are equal or greater than what's in the CDC eviction moratorium, that local jurisdiction, that local ordinance, or that state ordinance takes precedent. And that's what Governor Newsom has said. He's come out to say that California's bill, AB 3088, has greater protections in place. Now, this hasn't been tested by a court yet, and it may be here in the near future. But in the meantime, it's pretty safe to say that Californians can rely on AB 3088 in lieu of the CDC eviction moratorium. So now we're going to move into the AB 3088 frequently asked questions, and there are quite a few here. I want you to leave your other questions in the comments below, but let's dive into some of the most common that we've come across so far. Number one would be, does AB 3088 apply to commercial properties? And by commercial, they mean industrial, retail, office. The answer is no. This bill is exclusively for residential, and that's one or more. So technically a giant multifamily building of 150 units is considered commercial, but it's residential for the case of this bill. So this bill does not apply to commercial buildings. It does not apply to industrial, retail, office, but it does apply to all residential. So our second most popular question, can I as a landlord move back into my house? So the short answer is yes, but there's a few things that we need to make sure on. That is, the tenant has to be coming up on the end of a lease or must be month to month. They must be given proper notice, a 30 or 60-day notice. Make sure it has the correct language on there. Make sure it's delivered properly. Once those things are done, as long as it's going to be the landlord, a domestic partner, a spouse, a child, a grandchild, a parent, or a grandparent, then that tenancy can be terminated and that family member can move into the rental unit. A few more questions related to some of the nuances. Does a tenant from September to January need to pay 25% each month? And the answer is no. The tenant can wait till the end, could wait till January 30th, and then pay the equivalent of 25% for every month that was missed. Miss all 5, that works out to 125% of 1 month's rent. And another question related to this that we discussed. Can the tenant be evicted for not paying the other 75%? The answer is no. So landlords have asked, how do I know if my tenant's a high income tenant? Per the bill. So as we discussed, that tenant needs to submit proof that COVID-19 has affected their income. So here's where it gets tricky. A landlord cannot request proof of income to show that that is a high income tenant. So what the landlord needs to have is maybe in the original application something that shows that the tenant is high income. From there, the landlord then must make sure that their income is a minimum of $100,000 or 130% of the median income. Where do you get this number? And it's the median income for the county. We found it for you. So we've got a link below that has the state's breakdown for each county what the median income is. So from there you go ahead and you look and you pick the number of people living in the unit. You look at the median income number and you multiply it by 1.3. If you have proof of income from before now, so their original application, and you know they make that number or higher, then you can request the proof that their income was affected by COVID-19. Here's a quick idea. So in Orange County, for a family of 4, it would need to be just over $130,000. For the county of LA, it needs to be just over $100,000. But in the link below, we have all the different counties in California. Another very important point is that a local ordinance may take precedence over AB 3088. So here's a couple of quick examples. One is if there's an eviction moratorium that goes through the end of the month that prevents any evictions whatsoever, maybe also applies to commercial properties. So some local municipalities put some of those in place. Those take precedence over AB 3088, which may have allowed in that area some evictions to move forward. That eviction moratorium, the local ordinance, takes precedence. Another prime example is if a local municipality states that no rent has to be paid by a tenant before January 31st, 2021, then that 25% minimum requirement of AB 3088 would be null and void. The local municipality's ordinance would take precedence over AB 3088. That's why it's important to find the appropriate professional who understands eviction laws and the local ordinance as well. So make sure when you're looking out there for an attorney, they understand all the different levels of eviction law right now. And the last frequently asked question, did you hit the like button and hit the subscribe button yet? Hey, who put that on there? Just kidding, just kidding. Hey, we appreciate you tuning in. We appreciate you helping us get past the 1,000 subscriber mark. We're just gonna keep on running up. We've got a lot more content coming, so I wanna make sure you do a few things. Make sure you hit that like button. Leave a comment below, any questions you have. These ideas, these things I cover, a lot of them come from the questions that you're asking, and I wanna make sure that you get the answers that you need. Make sure you subscribe to our weekly email newsletter. We have some exclusive content in there. We want to make sure you see that. And we are real estate brokers in California. We can help you anywhere in the state. If we don't cover it, we'll find somebody who does. And we can help across the nation. If you need to find a good real estate broker somewhere else, we can help with that. So just remember, we're your real estate resource. Thanks for tuning in. This has been Christian Walsh, Coldwell Banker Wire Associates. We'll see you next time.